Washington, D.C. It was supposed to be another uneventful Tuesday in the Capitol, just another subcommittee hearing that no one would remember, buried beneath hours of dry legal jargon and procedural minutiae. The topic on the agenda: judicial ethics and public trust in the federal judiciary. A mouthful of policy fluff to most. But Representative Jasmine Crockett saw something very different. By 8:15 a.m., the hearing room in the Rayburn House office building was already full. The seats behind the panel were packed with reporters, legal scholars, and a scattering of activists clutching signs that read things like "No one is above the bench" and "Ethics for all branches." The air was heavy, not with expectation, but with the dull formality of yet another congressional theater production. But then Clarence Thomas walked in. The 76-year-old Associate Justice of the United States Supreme Court had never testified before a House committee during his entire tenure, until now. The invitation was voluntary, sure, but under intense public pressure following a wave of investigative journalism about undeclared gifts, luxury trips, and connections to political donors, Thomas had agreed to speak. Not under oath and not under subpoena. But the mere fact that he showed up had tongues wagging. He entered with the deliberate slowness of a man who had nothing to prove. Dark suit, crisp tie, expression unreadable. His presence drew an audible shift in the room. The chatter died instantly. Phones were lifted, cameras zoomed in. And on the opposite side of the room, Rep. Jasmine Crockett, dressed in her trademark power blue suit, locked eyes with the man she'd been quietly researching for weeks. She didn't flinch, not even a little. This wasn't just another hearing for her. It wasn't even about Clarence Thomas personally, at least not at first. It was about what he represented, the perception that the highest court in the land was somehow immune to the standards that applied to every other public servant, and in Crockett's mind, that was unacceptable. Justice Thomas, thank you for joining us today. Chairwoman Sylvia Hernandez began with the kind of sterile welcome reserved for formal occasions. Thomas gave a slight nod in return. No smile, no words. The early questions were predictable. Soft pitches from Republican members about separation of powers, judicial independence, and whether public scrutiny had gone too far. Thomas deflected politely. When asked about the now infamous ProPublica investigation that revealed years of unreported luxury vacations paid for by billionaire donors, he calmly insisted that all travel had been cleared by court advisors and that no conflict of interest existed in any decision I've made. Then came Rep. Crockett's turn. Justice Thomas, Crockett began, adjusting the microphone in front of her. Her voice was firm, but even deliberate. You've said more than once that your decisions have always been made in the interest of justice, not personal gain. Thomas gave a short nod. And you've also stated, quote, "There is no circumstance under which I would allow my integrity to be compromised." Correct? That's correct, he replied, his voice deep and measured. Then I'm sure you won't mind if I walk the committee through a few records I've obtained. A murmur rose in the gallery. Thomas furrowed his brow, just slightly. Crockett opened a thick binder, thick enough to be heard through the microphone. She didn't rush. Her pacing was surgical. This document, she said, holding up a color-printed spreadsheet, is a flight manifest from March 2017. It shows a private jet, tail number N242BR, leaving Teterboro Airport in New Jersey and landing in Jackson Hole, Wyoming. She paused. You were on that flight. The plane belongs to Harlan Crow, a name you've become quite familiar with lately. Can you confirm this? Thomas didn't answer immediately. My understanding, he said finally, is that that trip was for personal reasons and cleared by ethics counsel. But you didn't disclose it on your annual financial report for that year. Thomas shifted. That was a clerical oversight. Was it also a clerical oversight, Crockett said, raising her eyebrows, when you failed to disclose the yacht trip in 2019 or the Indonesian vacation in 2021? The room went silent. Chairwoman Hernandez raised a hand. Representative Crockett, let's stay within the bounds of decorum. With respect, Madam Chair, Crockett said without breaking eye contact with Thomas, I am simply asking a sitting justice why repeated non-disclosure of high-value gifts does not constitute a violation of the same ethics standards that apply to literally every other federal employee, including myself. Thomas was still, but his jaw clenched. This hearing, he said after a long beat, was billed as a discussion on judicial ethics, not a personal trial. Crockett leaned in. And this country, she replied, was built on the principle that no one is above accountability, not even the Supreme Court. What happened next wouldn't just change the course of the hearing, it would ignite a media firestorm. Crockett pulled out a glossy folder and flipped it open with practiced precision. I have here a list of decisions made by this court in which parties involved had direct or indirect financial relationships with your known associates, including Mr. Crow, Leonard Leo, and others. Thomas interrupted for the first time that day, his voice rising slightly. Representative, if you're accusing me of corruption, I suggest you tread very carefully. Crockett didn't flinch. In fact, she smiled, just slightly. I'm not accusing, she said. I'm asking, because the American people are watching, and they deserve to know if the scales of justice have been tipped by the weight of unchecked privilege. A beat. Do you want to see the receipts, Mr. Justice? There it was, the line that would dominate headlines for days. Twitter exploded within minutes. Receipts. For Thomas trended globally by noon. Crockett opened her folder again. In Wilkins v. EPA, the petitioner was represented by a firm with close ties to one of your undisclosed donors. In Branford v. FTC, the majority opinion, which you authored, benefited a real estate interest group partially funded by, guess who, Harlan Crow. Do you still stand by your statement that no conflict of interest exists in any decision you've made? Thomas's face was stone. I do. Crockett leaned back in her chair. Then I truly hope, for the integrity of this institution, that the American public believes you, because I have a feeling they're going to be the real judges here. What started as a tense moment in a committee room quickly became national news. Within 24 hours, clips of the exchange between Clarence Thomas and Jasmine Crockett had flooded every major platform. CNN ran it in prime time. MSNBC called it a reckoning for the bench. Fox News tried to downplay it, but even they couldn't avoid the spectacle. Twitter, now X, was in meltdown mode. Activist groups picked it up immediately. Hashtags like Ethics Matter, had Thomasgate, and Have Receipts. For Thomas were trending globally. Legal TikTok creators began analyzing each line Crockett delivered, comparing them to official court documents. She didn't just accuse, one viral post said. She constructed an argument like a prosecutor in closing remarks. Outside the Supreme Court building, a crowd gathered. By Friday, it had swelled to thousands. Protesters held up signs that read, "Corrupt bench, rotten justice. We trust law, not luxury. Crockett 2028. Clarence Thomas, for the first time in decades, became a household name not for a court ruling, but for a scandal he could no longer brush aside. At the Supreme Court, panic was setting in. Though the court officially remained silent, the justices' private chambers were anything but calm. Chief Justice John Roberts called an emergency conference, not to discuss a ruling, but to address the growing perception of judicial misconduct. The room was divided. Some justices, particularly the newer ones, believed Thomas should issue a statement of clarification. Others argued silence was safest. But the problem was, this time silence was loud. Meanwhile, across town, Jasmine Crockett sat in her congressional office, sifting through a new stack of documents. Whistleblowers had started reaching out. Former clerks, ethics officers, a retired federal judge. One email, sent anonymously, caught her attention. There were multiple internal warnings about Thomas's ties to Leonard Leo and luxury benefactors. Ethics compliance officers were told to stand down in 2016. You didn't hear it from me, but you're not wrong. Attached, a memo titled Justice Travel Guidelines Exception Review 2016. It showed policy changes made quietly, removing the need for justices to declare gifts received in a personal context. The signature at the bottom, Thomas's chief legal advisor. Crockett leaned back in her chair. She didn't smile. She never smiled at stuff like this. She just picked up her phone. Tell the chairwoman I'll need another hour in the next hearing, and tell the media team, we're not done. By the following week, pressure on the judiciary had reached a boiling point. A coalition of watchdog organizations, Citizens for Responsibility, the Brennan Center, Public Citizen, and even the Federalist Society's more moderate wing, called for an ethics investigation into Thomas's conduct. They weren't demanding removal yet, but the pressure was unmistakable. Then came the bombshell. C-SPAN obtained audio from a closed-door judicial conference in 2018 in which Thomas joked about the perks of seniority and never flying commercial again. The audio didn't confirm anything illegal, but it shattered the court's image of austere impartiality. Crockett was invited back for a televised sit-down with PBS. When asked if she had coordinated the timing of her confrontation with MediaLeaks, she simply said, I confronted the facts. What the country chose to do with them isn't on me, but I won't apologize for expecting honesty from a Supreme Court justice. In private, her staff was overwhelmed. Donations were pouring in, volunteers flooded her inbox, law schools were asking her to speak, and then the New York Times dropped a headline that changed everything. New allegations suggest pattern of undisclosed financial ties, Thomas's decisions under renewed scrutiny. The pressure was unbearable, even for someone as insulated as Clarence Thomas. For decades, he had operated behind the protective glass of lifetime tenure, rarely giving interviews, almost never addressing criticism. But now, the scrutiny was national, bipartisan, and unrelenting. He could no longer rely on silence. So his team made a decision: go public. Thomas appeared in a pre-recorded interview with a conservative legal podcast titled Original Intent. The setting was controlled, the lighting was soft, the questions had clearly been vetted in advance. He looked calm but tired, the weight of decades in his eyes. I've always served with integrity, he said, voice low. These attacks are political. They're meant to undermine the court because certain people don't like the outcomes of our rulings. The host nodded vigorously. Do you deny any wrongdoing, Justice Thomas? I do. I've followed all guidance available to me. I've done nothing improper. But the problem wasn't just about legality anymore. It was about perception, credibility. And in that arena, he was losing badly. That same evening, Jasmine Crockett posted a quiet, one-line tweet that detonated across the internet. Let's not confuse silence with guilt, or sound bites with truth. Receipts coming soon. Shout receipts. Coming trended within hours. What Crockett dropped next was not a leak. It was a coordinated legal maneuver. During a follow-up hearing, she presented what she called the pattern file, a compiled set of 142 pages showing 12 cases where parties had direct financial connections to entities Clarence Thomas was later linked to through travel, gifts, or undisclosed income. She didn't yell. She didn't even raise her voice. She simply placed the file on the committee table and said, if this level of proximity existed between a federal judge and a plaintiff in any lower court, district or appellate, that judge would be disqualified, possibly disbarred. So my question is simple. What makes the Supreme Court exempt from accountability? It was a kill shot. The file included a 2004 ruling in favor of a telecom giant linked to Thomas's friend's real estate portfolio, a dissenting opinion he issued in a campaign finance case while attending a donor retreat organized by a PAC directly benefiting from that ruling, a 2015 vote denying a hearing for a case involving indigenous land rights, weeks after staying at a private lodge partially owned by a corporate lobbyist in the dispute. The media devoured it. Legal scholars began dissecting each entry. Ethics watchdogs were now calling not just for new rules, but for retroactive review of Thomas's rulings. And somewhere inside the marble walls of the Supreme Court, Clarence Thomas realized something chilling. He wasn't being accused by the public. He was being prosecuted by history. Crockett didn't expect Thomas to come back, but he did. Under intense political pressure and with his legacy on the line, Thomas agreed to return to the House for a second round, this time with no script, no safe podcast, and no buffer. It was live, raw, televised on 5 networks. The atmosphere felt more like a courtroom than a committee hearing. Every seat was filled. Dozens of press photographers lined the walls. You could hear the hum of anticipation, like a courtroom before a verdict. Chairwoman Hernandez opened the session. Today's hearing will be guided by one question. Does the current structure of the Supreme Court allow for ethical abuse without consequence? Thomas spoke first. He stuck to his line. I've followed all rules as understood at the time. But his voice cracked. Just slightly. Then came Crockett. She didn't rehash her previous arguments. She brought something new. A former Supreme Court staffer, testifying anonymously, had provided travel logs showing Thomas's private trips overlapped with conferences and donors who had cases pending before the court. The staffer claimed an internal memo was submitted urging recusal and ignored. Crockett looked at Thomas, not in anger this time, but in cold disappointment. Justice Thomas, when you say, I followed the guidance, are you referring to the same memo you were handed and chose to ignore? He didn't answer. Because if you are, then what we have here isn't just negligence. It's deliberate avoidance of accountability. Gasps in the room. Thomas gripped the microphone. Representative Crockett, I refuse to be lectured on integrity by someone who... She cut him off. Not with volume, but with precision. By someone who what? Someone who believes the law applies to all of us? You may have your robe, Justice, but I have my receipts. The hearing room erupted. The consequences came swiftly. Not legal, but reputational. Chief Justice Roberts issued a rare public statement days later, saying the court would adopt a formal code of ethics. It was a face-saving gesture, but also an admission that the court could no longer remain untouchable. Crockett's political star soared. She received invitations to keynote civil rights events, judicial symposiums, and international law panels. Young lawyers began referring to her method as the Crockett Standard, fact-based, fearless, forensic. The final blow came when Gallup released a poll showing public trust in the Supreme Court had fallen to an all-time low, 34%, with Clarence Thomas specifically receiving a disapproval rating of 63%, even among some Republican voters. And still, Crockett stayed quiet. No victory lap, no gloating. In a rare interview with 60 Minutes, she was asked, how does it feel to have taken on a Supreme Court justice and won? Her reply was instant. I didn't come here to win. I came here to remind people that power isn't protection, not from truth, not from consequences. As history looks back on the confrontation between Clarence Thomas and Jasmine Crockett, it may not frame it as a legal battle. It wasn't a trial. It was a reckoning. A young congresswoman from Texas walked into the lion's den, not with rage, but with receipts. She didn't destroy a man. She revealed a system, one that allowed a select few to rise so high they believed they could never fall. But fall they did, and the echo of that fall, captured in camera lenses and congressional transcripts, will ring through America's democratic memory for decades. Because sometimes, the most powerful gavel isn't the one in the judge's hand. It's the one held by the people, or by someone brave enough to speak for them.